Hello and welcome to another video. If you haven't seen me before, my name is Amy. I run HR and business related content across social media platforms. I'm also an independent HR consultant. Quick disclaimer, this video is for informational purposes only. It does not constitute legal advice, nor is it an exhaustive summary of the law. Today we're going to discuss the legal options available when an employee in the UK experiences bullying at work. So the first port of call when an employee experiences bullying is probably going to be the internal grievance procedure. This formal process allows the employee to report bullying to their line manager or HR department. The employer then has a responsibility to investigate the allegations, mediate where appropriate, and take steps to prevent further incidents. If the bullying is related to a protected characteristic such as age, disability, race, religion, sex, sexual orientation, or gender reassignment, then it may fall under the definition of harassment under the Equality Act 2010. The Equality Act makes it unlawful for employers to permit conduct that creates a hostile, intimidating, or offensive environment due to one of these protected traits. If internal steps fail, a claim may be brought before an employment tribunal. In some cases, bullying becomes so severe that it causes an employee to resign. This may give rise to a constructive dismissal claim. For this to be successful, the employee would need to show that the employer breached the implied term of mutual trust and confidence, typically by failing to act on reports of bullying. It's typically brought to an employment tribunal and generally requires the employee to have worked for the employer for at least 2 years. Where bullying has led to psychological harm, such as anxiety, depression, or stress, an employee may have grounds to bring a personal injury claim. This route requires evidence from a medical professional and demonstration that the employer breached their duty of care. Unlike tribunal claims, personal injury cases are pursued through the civil courts. If the bullying involves repeated and severe conduct, the Protecting from Harassment Act 1997 may apply. This law makes it illegal to pursue a course of conduct that causes harassment, alarm, or distress. Claims can be made through civil courts, and in serious cases may even lead to criminal charges. Bullying that includes discriminatory treatment can be addressed under UK discrimination laws. For example, bullying rooted in racism, sexism, or disability discrimination could lead to a discrimination claim before an employment tribunal. These claims can result in financial compensation, reinstatement, or changes to workplace procedures. Although there is no single law against bullying in the UK, several overlapping legal protections exist. Employees may seek remedies through internal grievance processes, harassment or discrimination law, constructive dismissal, personal injury claims, or the Protection from Harassment Act. Each route depends on the facts, the nature of the conduct, and the employee's circumstances. Now we're going to look at some relevant case law. There are several landmark cases illustrating how UK law handles bullying-related claims. The first one in terms of harassment, Richmond Pharmacology against Dhaliwal. In this case, Mr. Dhaliwal was subject to racially insensitive comments from a senior colleague. The Employment Appeal Tribunal found that the comments constituted harassment under the Equality Act 2010, creating an offensive environment, and the employer was held liable. Another case in terms of constructive dismissal got Western Excavating against Sharp. So Mr. Sharp resigned and claimed constructive dismissal after his employer's conduct made continued employment impossible. The Court of Appeal held that a fundamental breach of contract is required for such a claim. Failure to protect against bullying may qualify as such a breach. So a teacher suffering from extreme stress due to the lack of support successfully sued the council. The House of Lords held the employer liable for breaching their duty of care to protect his mental well-being. And the final case we've got with the Harassment Act, Ferguson against British Gas. Miss Ferguson experienced aggressive and repeated contact from British Gas regarding an erroneous debt. The Court of Appeal ruled in her favour under the Protection from Harassment Act 1997, reinforcing that sustained organisational conduct can constitute harassment even outside a workplace setting. So just to summarise, employers have a legal and moral obligation to prevent workplace bullying and harassment. Failure to act can result in legal liability through multiple channels, some of which can be financially and reputationally damaging. To reduce risk, organisations should implement anti-bullying policies, ensure effective compliant mechanisms, and train managers to respond appropriately. For more UK employment law insights, subscribe to the channel and let me know what topics you'd like me to cover next. Thank you for watching. Bye.